matter of the referral. Mr. Speaker, they have submitted their report to the House. And my own thinking, and indeed candid assessment of the situation, is that Mr. Speaker, my own candid assessment of the situation is that once the committee has made a determination in respect of the three persons, the imperatives of Article 97 would automatically be triggered. Mr. Speaker, so my thinking is that even what is captured here as a motion, the purpose of a motion is for the House to make a determination. And I'm thinking that really this is not for the House. It's not for plenary to make a determination. Mr. Speaker, so I think that even locating it on the other paper in itself is unfortunate and indeed unnecessary. It should not have been listed on the other paper. What information that comes from the committee should be submitted to us as a paper. Mr. Speaker, that's where we are, and maybe we have to talk to the issue before we adjourn the meeting.
I've heard the majority leader refer to motion 55, which motion reads that this Honourable House adopts the report of the Committee of Privileges on the alleged breach of Article 97(1)(c) of the 1992 Constitution and Order 16(1) of the Standing Orders of Parliament by 3 honourable members of Parliament during the first meeting of the second session of the 8th Parliament of the 4th Republic of Ghana. And Mr. Speaker, even as he rose, he didn't move the motion, yet he didn't move the motion. He is now expressing an opinion. Mr. Speaker, this House is governed by the 1992 Constitution and the Standing Orders of Ghana. There is a motion in motion 55. Mr. Speaker, even by our standing orders, motion is defined to mean a proposal made by a member that Parliament or a committee thereof do something or order something to be done or express an opinion concerning some matter. If he is moving a motion, let him move it. But to rise on a motion and say my view, Mr. Speaker, let me state with emphasis and with respect, Mr. Speaker, my words may be strong, so you have to find favor to live with those words. That Parliament and the Parliament of Ghana is not the Speaker of Parliament, and that the Parliament and Parliament of Ghana is not the chairman of the Subsidiary Legislation Committee of Parliament, and that Parliament is not the majority leader, nor is it the minority leader. That the Parliament of Ghana is the well-constituted 275 members of Parliament elected thereon to exercise the legislative authority of Ghana on their behalf. On their behalf. And therefore, Mr. Speaker, when he moves motion 55, Mr. Speaker, I have to indulge you as I said. This House must be guided by precedent. Mr. Speaker, you rightly in your judgment, I respect your knowledge and experience with the rules better than mine. I can never challenge you when it comes to procedure. But Mr. Speaker, you refer this matter to a committee. The committee have come by motion. He is not moving the motion. But Mr. Speaker, let me remind him, leader, in 2005, you were in this August House when Eric Amoate was arrested on the criminal charges in the United States of America for cocaine. The Privileges Committee of this August House was called to exercise a duty similar to the duty we are exercising today. In November 2005, Parliament took a decision on Eric Amoate through the Privileges Committee report. The Supreme Court, Mr. Speaker, and I'm going to beg you, so if he's moving a motion, move a motion. This is not the first time the Privileges Committee of Parliament is making a recommendation to the Parliament of Ghana. In 2005, Parliament took a decision, which decision did not find favor in the judgment of our respected judges of the Supreme Court in the case of Professor Stephen Kweku Asare versus the Attorney General, the Speaker of Parliament, the Electoral Commission, and 4, Honorable Eric Amoate, judgment registered 11 December 2008. Mr. Speaker, you were here with him in 2005. I was here too, but young those days, inexperienced those days. Mr. Speaker, I want the answer to capture the full judgment of the Supreme Court on the matter. But Mr. Speaker, what is significant? What is significant? So I want to know whether he's moving a motion or he wants to express an opinion. But Mr. Speaker, let me caution that let us not set precedents that tomorrow a Privileges Committee will come and submit a report, and on the basis of that report, an elected member of Parliament will be asked to go home and a seat declared vacant. Mr. Speaker, you brilliantly, in your directive for the committee to work that day, refer to Article 97 of the 1992 Constitution. With respect, Mr. Speaker, let me refer you to the same article and espouse some position on it. Mr. Speaker, Article 97 reads, 1, and I quote, "A member of Parliament shall vacate his seat in Parliament. Vacate his seat in Parliament. 1, upon the dissolution of Parliament, or B, if he is elected as Speaker of Parliament, or Mr. Speaker, for our purpose today, C, and it reads, if he is absent without the permission in writing of the Speaker." Evidence abounds that those 3 persons did not get your permission when they didn't get your permission in writing. And I'm not aware of any reasonable explanation to the Parliamentary Committee on Privileges from 15 days. So the explanation is from 15 days. They have absented themselves during any period that Parliament has been summoned to meet and continue to meet. Mr. Speaker, I know the motion has not been introduced, but I'm raising procedural issues so that my colleague walk on the path of procedure. I know you know it well. So, but Mr. Speaker, I'm to remind him that I have no problem with members of Parliament who are in breaches of this Constitution must be held solely responsible to those breaches. And there should be no cover up for any elected member of Parliament when you absent yourself without permission in writing from the Speaker for 15 days consecutive. But Mr. Speaker, the 3 you referred to, it says to the Privileges Committee. So Mr. Speaker, I have a question to ask even before he proceeds. So the Privileges Committee report they have given to us, to do what? To do what? What is Parliament to do? It is not for me to express my own opinion, but my opinion will be that this is Parliament, this House, the elected MPs, 275, we are Parliament. Therefore, if a report has been submitted to us, we must take a decision as a House on that report. As a House, elected members of Parliament. That is what happened in 2005 when the Amoate thing happened. So let's not change the rules today because we may not want an Adjoa Sarfoa or a Henry Cote or a Kennedy Japan to be subjected to the full requirement of the Constitution under Article 97. Mr. Speaker, so what are we to do? Mr. Speaker, I guard jealously that Parliament is the guardian and the protector of fundamental rights and freedoms. Mr. Speaker, it's not for nothing that in this Constitution there is no provision how to remove an elected member of Parliament. It's not for nothing. Because the Constitution respects the weight of an elected person who wields the power and authority of the sovereign. When you are elected here, it is because we have cheapened ourselves that appointees are heavier or holier than us. But We are elected members of parliament. So, Mr. Speaker, let the leader come clear. In 2005, Eric Amoate, the narcotics criminal, went through privileges committee. This house took a decision. But, Mr. Speaker, before I hear him, for the record, I've said that table, you publish the entire judgment. But, Mr. Speaker, Justice Aban, respected Justice Aban J.A., Akwa J.A., Adjoa Sarfoa J.A., they said, and Mr. Speaker, let me read this for the record so that my colleagues like Honorable KTM or my senior in the law will follow. Mr. Speaker, it reads, the undisputed facts resulting in this appeal are that in November 2005, the Honorable Eric Amoate, Member of Parliament from Koranza North Constituency, understanding Order 15, obtained the Speaker of Parliament permission to absent himself from Parliament from 17 November to 24 November 2005. He then traveled to the United States of America, where he was arrested and detained for possession of narcotics drugs. Unable to attend Parliament, Eric Amoate sent his lawyer with a letter to the Speaker some 3 months thereafter, explaining the cause of his continued absence from Parliament and requesting for an indefinite leave of absence. Mr. Speaker, this emphasis is mine. The Speaker referred the letter to the Parliamentary Committee on Privileges, which met on 22nd February 2006 and recommended to the House of Parliament on 2nd March 2006. Therefore, any recommendation coming from the Privileges Committee must be subjected to the same threshold of legal and constitutional requirement as defined in the ruling of Justice Aban and Co. And Mr. Speaker, the House, it says, the House of Parliament on 2nd March 2006 to grant the honourable member an indefinite leave of absence after some debate. So, Mr. Speaker, any motion or report moved today must be subjected to debate by this August House. After some debate, Parliament granted the honourable member an indefinite leave of absence to fight the drug case in court in the United States of America. That is how a cause of action arose in the Supreme Court of Ghana. And Mr. Speaker, the judgment of the Supreme Court, for emphasis, I'll read in page 4. I've already found out that the maximum period the Speaker could allow a member of Parliament to absent himself from Parliament is 15 days. It is unacceptable for Parliament to grant a leave of absence longer than envisaged under Article 97(1)(c) of the Constitution and the Standing Orders of Parliament. I find that it was unlawful for Parliament to grant the honourable member of Parliament indefinite leave of absence. So whatever we are doing today, Mr. Speaker, I'm saying let's be guided by the 1992 Constitution, our standing orders, and the precedent. Mr. Speaker, my disappointment is President Nana Addo Dankwa. Even this, he should fire the minister. If you are a minister and you are not at post for long, which one must precede what? No. But this Parliament, as I've said, Mr. Speaker, there is no way in this Constitution how a member of Parliament can be removed. Maybe we'll go to the provisions on how the Speaker is removed and learn from it, but it's for good reason. You don't take, you can take decisions yesterday. I'm saying, Mr. Speaker, I'm surprised that Nana Addo Dankwa is not showing wit and will in dismissing the absentee minister. Why will you be keeping an absentee minister and thinking that you find comfort in Parliament dismissing and declaring the seat vacant? So, Mr. Speaker, let the leader come clear and we'll know his intentions and we'll fight his intentions. I thank you for the opportunity.
Speaker, thank you very much. Mr. Speaker, when I first started, I raised the issue about procedure. How come we have a motion listed as item 55, which reads that this House adopts the report of the Committee of Privileges on the alleged breach of Article 97(1)(c) of the 1992 Constitution and Order 16/1 of the Standing Orders of Parliament by 3 honorable members of Parliament during the first meeting of the second session of the 8th Parliament of the 4th Republic of Ghana. Mr. Speaker, my initial issue has to do with procedure. And I said, I'm convinced that this matter should not be subjected to a motion that will then need the approval of Parliament. My colleague started by saying that there is a precedent. If a precedent is bad and cannot be foundation on the Constitution, you cannot foist it on Parliament. Mr. Speaker, he cites one example. Mr. Speaker, you are aware that for 6 years since the inception of the Fourth Republic, resolutions in this House were approved by 2/3 majority in this House. Until we entered this House and the issue came up that what Parliament had been doing for 6 years was unfortunately not based on the Constitution. Justice Annan was the Speaker. So what precedent had taken place for 6 years was dismantled in a day. It was bad precedent. And then resolutions, more than 500 resolutions had been passed by this House, predicated on 2/3 majority. The fact that it was bad could not be justified by the fact that it had precedence. So a wayward precedent should not have any effect on this House. Mr. Speaker, that's the first lesson to him. Mr. Speaker, now the issue that he raises about Article 97. Mr. Speaker, for his elucidation, Article 97, we all do know, provides. Mr. Speaker, we are talking about constitutional imperatives, not personal sentiments. Mr. Speaker, Article 97 that he read provides, a member of Parliament shall vacate his seat in Parliament. A says, upon a dissolution of Parliament. If Parliament is dissolved, vacancy is declared for all of us, collectively and individually. There is that automaticity. Mr. Speaker, B says, if he's elected Speaker of Parliament. Mr. Speaker, the Speaker of Parliament, Speaker Adjoa, was a member of Parliament, duly elected by his constituents. When he was nominated and indeed elected as Speaker of Parliament, the Speaker, immediately after the election, his seat fell vacant. There was that automaticity. The Speaker, now let's come to 97. 1C. It says, a member of Parliament shall vacate his seat in Parliament if he is absent without the permission in writing of the Speaker. That's the first leg. The Speaker, those three people, if they had sought your permission and you had granted the permission, you would not have referred their conduct in the first place to the Privileges Committee. It stands to reason that they flouted that first leg. That is why he referred their conduct to the Privileges Committee. The Speaker, the second leg now states, if he is absent without the permission in writing to the Speaker and is unable to offer reasonable explanation to the Parliamentary Committee on Privileges from 15 sittings of a meeting of Parliament during any period that Parliament has been summoned to meet and continues to meet. The Speaker, that is what the committee was tasked to investigate, whether they have reasonable excuse after not having sought your permission, whether they have reasonable excuse to have absented themselves. Mr. Speaker, that is what the three of them were required to do, to submit themselves to the Privileges Committee, to justify whether or not they had reasonable excuse. Mr. Speaker, the Privileges Committee has submitted their report. And my considered opinion, based on the Constitution, not on sentiment, is that there should be that automaticity once the committee makes a determination. According to saying that it should be decided by the House, I disagree with him. I disagree with him. There's no constitutional basis for what he's saying. The Speaker, I say so because he himself has not cited any constitutional provision to that effect. He is speaking to his sentiments, which has no relevance as far as this matter is concerned. Mr. Speaker, Article 112 provides that once the determination has been made and the vacancy has fallen, 1125 says, whenever a vacancy occurs in Parliament, the Clerk of Parliament shall notify the Electoral Commission in writing within 7 days after the vacancy occurred, and the by-election shall be held within 30 days after the vacancy occurred. Mr. Speaker, the determination of the committee is born in a report that is submitted to this House. And that report is not for the consideration and voting on by this plenary. It is for the information of the House that the determination has been made. Mr. Speaker, my colleague appears to be arguing that no committee can make such a decision that will bind the entire House. He's totally wrong. Mr. Speaker, let's deal with what is contained in Article 106. Article 106, sub 13. Article 106, sub 13 provides, and again for his elucidation, I'll read, where it is determined by a committee of Parliament appointed for the purpose that a particular bill is of an urgent nature, the provisions of the preceding clauses of this article, other than clause 1 and paragraph A of clause 2, shall not apply, and accordingly the President shall give his assent to the bill on its presentation for assent. The Speaker, the committees of this House has the authority to determine the urgency of a bill. Once they make the determination, it binds all of us. Plenary has no business in this. People should understand that. So this is not the first time a committee is authorized to make a declaration for and on behalf of the House. Again, Mr. Speaker, let the minority leader address his mind to Article 177 of this Constitution, which provides Mr. Speaker, Article 177 is on the creation of the contingency fund and how funds can be withdrawn from the contingency fund. It provides, there shall be paid into the contingency fund monies voted for the purpose by Parliament, and advances may be made from that fund which are authorized by the committee, not Parliament, authorized by the committee responsible for financial measures in Parliament, whenever the committee is satisfied that there has arisen an urgent or unforeseen need for expenditure for which no other provision exists to meet the need. So in that case, it doesn't come to plenary. Mr. Speaker, fancy a situation where the finance minister makes a request to the committee authorizes him to maybe withdraw about 50 million Ghana cedis from the contingency fund. And then the report comes, and then your Parliament says that you don't subscribe to that. What happens? What might have happened would be that the minister, after spending the money, your committee having agreed to that, then you charge the committee for causing financial loss. Is that your understanding of the Constitution? You're totally wrong. Mr. Speaker, so committees of this House have the authority in these three specific areas to carry on what is required of them, the authority that they have been clothed in by the Constitution. So my colleague is totally out of sorts, with the greatest respect to him. He's my friend, and he sounded that he was going to use hard language. Mr. Speaker, I believe I have restrained myself in not using hard language. I've been very circumspect, but I believe that I'm right. He's totally wrong. So, Mr. Speaker, The point I'm making is that this motion ought not to have been listed for the House to approve of the report of the Privileges Committee. That is totally an absurdity. That is it. So, Mr. Speaker, that is the legal position. And I challenge him to use the Constitution to disprove what I'm saying. Mr. Speaker, he quoted the standing orders. I will suggest to him that, yes, the standing orders is supposed to be a product of the Constitution, but between the standing orders and the Constitution takes precedence. We should know that. I thank you very much, Mr. Speaker.